Thank you very much. So on that note, which leaves a lot of thoughts resonating in the air about labeling for various nefarious purposes. Nefarious may not be the best word for that. And particularly that sometimes whilst the ICC may be shouting justice before peace, there is the possibility of peace before justice, and that is used by others, and they don't get labeled under the same circumstances. So upon that note, the floor is open for questions, comments. So sorry I'm pointing, but you, yes.
I would like to ask Mr. Griffiths first about this scandalous decision of the court for Sierra Leone concerning the dismissal of the judge from Senegal. I just wonder whether the dissenting opinion of that judge, who had, I think, the perfect right to announce that decision and to read it out, whether this is being duly attached to the opinion of the court as it should be, and secondly, whether this judge has any possibilities under the rules of that particular court, which I'm not aware of in detail, to take action against this kind of decision. I'm aware of other dissenting opinions in international tribunals, like that one in Tokyo, for instance, where the Indian judge made that famous dissenting opinion, and he was not in any way, he was not removed by the court. And if I may just very briefly ask Mrs. Evenson about what she said when she used that nice metaphorical term, unlocking potentially universal jurisdiction of the ICC. Should we really say that the ICC has potentially a universal jurisdiction? Is it not simply just a treaty-based jurisdiction in regard to territoriality or nationality, and a jurisdiction that is to be exercised on the basis of complementarity? And should we not, if we are interested in the ICC being a success in the long term, advocate a slight amendment, so to speak, to the Rome Statute, which takes away from the Security Council that right to what you call unlock jurisdiction, because to unlock jurisdiction, which in actual fact does not exist and must not exist as long we are committed to international law, in my view, is an absolutely quintessential task. And if we complain about politicization of the ICC and so on, the first thing we should do is to suggest that the Security Council is not being given that particular role, and if it is given the right of referral, it should exercise it at the same level as any state party, but not in a way that allows it to create jurisdiction.
All right, I think that since the mic is on that table, you, and then you, and then you. Okay, let me change that order.
Thank you, Madam Chairperson.
You. Okay, all on the same table. And then you.
2 quick points, if I may. The first is I agree with the Speaker that the ICC is on trial, just as Africa is on trial at the ECC, at the ICC. One point is that the ICC had done a great deal of damage. For example, in Darfur, after the indictment of President Bashir, the rebels thought, now that the president has been indicted, it means the West is going to invade Sudan, is going to attack its port, is going to attack its air force, and they will hand us over government in the Sudan. That's what they really believed. That's why they refused to negotiate. They refused to reach a compromise solution. And they are still fighting until today from the territory of Southern Sudan. So so many people have died since the ICC ruling because it extended the conflict, extended the duration of the conflict. This is the first point. My second and last point is that the ICC flowered and matured during the neocon project and rule in the United States and its extensions. That did not go unnoticed to the general population because in the United States and in this country, in the United States, for example, there was also the population lost a great deal of democratic rights and privileges about the rights of the citizen. Many civil liberties were curtailed at the same time. And in this country, the Daily Telegraph, the day before yesterday, wrote that military people are being abused if they go wearing uniform in public places or they visit their children in school. So it has boomeranged also this attitude of disinformation and singling out African countries. It has boomeranged and it has damaged the democracy in this country and in the United States. The former leader of the Labour Party has written an article in which he said the general population is no longer interested in the main political parties. So this is part, because the spin, if your policies are based on spin, spin will be exposed, and then the people will be disappointed in you. Thank you very much.
Thank you. We would like questions. Thank you.
Sorry, mine is not a question. I just want to react a bit, but briefly, to what Professor Nyang'oro said, that one of the reasons why most African countries ratified the ICC convention was because of intellectual laziness. I disagree with him. You see, the major reason why they ratified is that foreign policy decision making in African countries is not as democratized as it is here in the Western countries. In Africa, particularly signing and ratifying international instruments is done by, most times, by heads of states. And these heads of states are susceptible or vulnerable to pressures from, of course, from the Western countries. All sorts of pressure. At times, economic pressure, they use economic means to pressure them into signing some of these documents. International instrument ratifications in most African countries do not go through the Senate, do not go through the House of Parliament or legislature as it is out here. So that is one of the reasons why a lot of African countries ratified ICC treaties, not because of intellectual laziness. Thank you very much.
Yes, you may go. You may go ahead, please.
I've got.
Please. Yes, you have the mic.
Oui, Omar, est-ce que vous pouvez traduire pour moi? Ok, d'accord. Mais il faut qu'elle aille au micro alors. Ben, je lui donne le micro. Voilà. En fait, c'est une question qui sera très brève.
A brief question.
Ouais, qui commence par un constat.
You want to start with a small statement.
Que l'Afrique souffre d'insuffisance structurelle et de l'ignorance qu'elle présente.
Africa suffers from
d'insuffisance structurelle.
Insufficient structures.
Ignorance.
Continue, comme ça.
A besoin
Africa needs
d'un leadership très fort.
Of a strong leadership.
Voilà, c'est bien de critiquer, mais je pose la question à mes frères africains.
It's good to criticize, but I'd like to ask my African brothers.
On fait quoi?
What should we do?
Voilà, parce qu'en fait, aujourd'hui, je réalise que trois mots suivants.
Today I realize the three following things.
Justice,
Three following words: justice,
autorité
authority,
et paix
and peace
ont été mal interprétés par l'humanité.
have been badly interpreted by humanity
Et ceux qui sont les maîtres de ce monde,
and the masters of the world.
ils doivent s'asseoir et faire leur mea culpa.
The masters of the world, should sit down and do their mea culpa
Parce qu'il y a trop d'inégalités
because there are too many inequalities,
et ce n'est pas juste. Et je pense que c'est
which is
même
not fair
honteux. Ça ne
and
les-
even shameful,
Voilà, ça ne les honore pas.
and it doesn't honor them.
Et-
Votre question?
Et la question, c'est donc aux panélistes.
Question to the panelists, all of you.
On est d'accord que ICC aussi présente des anomalies.
We're all in agreement that the ICC has some anomalies, shortfalls.
Et comme le docteur David Hoyle l'a dit, il a présenté 2 cas en Irlande du Nord et au Darfour. On a ouais, vas-y.
So, and as David Hoyle put the case for Darfur and Northern Ireland forward,
Il y a eu, comment on appelle ça, il y a eu comme comment on dit, une amnistie qui a été acceptée ici
there was an amnesty which was accepted here
et une amnistie qui a été refusée de l'autre côté.
and one which was refused in Sudan.
Mais au nom de quoi la Grande-Bretagne refuse l'amnistie au Soudan?
But how can Great Britain refuse amnesty in Sudan?
Oui, nous sommes tous les mêmes êtres humains. Et je ne comprends pas, je veux qu'on m'aide à comprendre. Est-ce que les questions de force
Can someone explain this inequality? Or,
ou bien c'est parce qu'on a plus d'âmes? C'est quoi exactement? Voilà,
Okay.
c'est tout.
So that's the question. Okay, thank you. And then this gentleman, and then it will move to that table.
Actually, it's just a quick point, really. It's not really a question. Just want to follow what Dr. Hoyle and Mr. Griffiths mentioned earlier. Recently wrote an article on the New York Times, actually last week, about the subject, the Western meddling on the Charles Taylor trial, mainly in The Hague, where a growing number of civil rights campaigners, left-wing think tanks, and I mentioned earlier today about Fleet Street newspapers, mention the concern or raise the concern of the ICC dealings. Actually, a code created for the crimes in one continent is by definition discriminatory. It's my point of view, and that's what I wrote, and incapable of equal justice. And that's quite simple. When we're looking at the cases of Thomas Lubanga to Laurent Gbagbo, Jean-Pierre Bemba, quite significant. And if there is to be a fair international criminal court, it must act equally as to all nations, with none above the law. I think this is sacrosanct. This is paramount.
There was a table where, yes. Now, after that, then we will come round again because we still have some time. So, because there's been a number of questions, not too many. But once we finish with this set, then we will go to the next group of people. Thank you. I think it would help if somebody would have gone around taking the names of those.
Thank you. My name is Tesfa Mahari from Greenwich University. I think it's just an observation to build on what my good friend said on the case of weakness of African states. For me, I try to see, yes, from the discussion, which was very enlightening, I do see there is Africa is on track. And with that, the way I would observe it is, why is it, do we see, or does the panel see this, for example, or can they relate it to the very democratic deficit which exists in Africa? the African states are getting winced or kidnapped, you can call them, to be tried and to be told of like a school child in Europe. And why is Africa accepting such humiliation? To a large extent, it is probably these states are weak, and their very existence to a large extent depends on, or in other words, they value their relationship with their external donors and external business networks rather than their own people. And if this is the case, then shouldn't at least the ICC, therefore, try to use its current effort in building those capacity and giving voice to those African people? And an example which I would try to cite is, instead of taking those people to The Hague, why don't you try, for example, if there is an issue with President Bashir in Sudan, the first people, the first victims are in Sudan. Why don't you carry the trial there, send all the experts that you can have, bring the crews to Khartoum, publicize it. And then at least when you leave, when the show moves on, even if the trial fails, then at least you can have people who have got some level of confidence in an institution there and trained people which will be there and build on what you have left. Thank you.
Thank you. Okay, so yeah, I knew there was another person on that table. Excuse me. There's somebody on that table, and then when we finish, we can have the feedback from here and then return to take more questions because we still have some time.
Hello, I just want to be brief. I just want to ask all the panelists that do you think the nomination of an African woman or an African person would change something to the ICC? Thank you.
Whether the presence of the presence of Fatou will change anything. Yes. All right. So we've got the first questions were specifically directed to Mr. Griffiths and then another question to Ms. Evenson. And then there were general comments, and then there were a number of general questions or questions generally directed as to what one can do in this sort of situation where the leadership, there's this problem of ignorance, institutional weaknesses, and weakness of leadership. And then there's also the question that of why is Africa standing for this treatment? That's also a general question. And then there is the question of whether we think having Madame Fatou Bensouda at the helm of the prosecution is going to make any difference. So I think we will simply go around and each person will answer their questions or simply speak to the general question very briefly, please, so they will have more time.
Very briefly on the referral of cases to the ICC by African countries, let's be practical. If we simply mention two cases, Uganda. As many of our colleagues have said, the biggest gift to Museveni in the last 3 or 4 months has been Courtenay 2012. Why? Because now Museveni, even though Uganda is one of the few countries in Africa which has a competent judicial system and could handle the trying of Courtenay, Museveni conveniently is pushing for the trial of Courtenay in The Hague because it does eliminate a political problem for him, which is if Courtenay were tried in Uganda, the issue of why Courtenay in the first place, why did Courtenay's movement gain momentum in Uganda would have to be addressed. And the answer to that question is because the regime in Uganda has not paid enough attention in terms of development, political rights, and things of the sort in northern Uganda, and then Museveni himself will be on trial. And by pushing the case to The Hague, then Museveni is handed a major victory. In terms of Kenya, again, it is a political problem of the opposite kind, which is if you were to try what was so-called the Ocampo 6, but now it's the Ocampo 4 in Kenya, what would happen? It will be politically chaotic in Kenya. And so none of the judicial system in Kenya would be able to handle the major political problem associated with these major political figures. And so the ICC becomes by default the avenue for domestic political problems, which we as Africans need to address in a very serious manner.
Can I address Professor Coakley's question first? We have always argued from the very outset of the Charles Taylor case that his prosecution was politically motivated. And an example of that is the date chosen for the declaration of the verdicts in the Taylor case, which just happened to be the day before the celebration of independence in Sierra Leone. So Taylor was in effect being handed as a trophy to the Sierra Leonean people. And once you appreciate that and the importance for the court of leaving behind this legacy that everyone who came before us has been convicted, then you understand why Justice Sowell was treated in the way he was. Because every lawyer knows a dissenting judgment has a very long and healthy pedigree in all Commonwealth countries. There's no magic about that. So why is it that the other three judges, and indeed the court, sought to censure a judge of that court from expressing the view that Taylor was not guilty? And it goes to this extent. Not only did they in fact switch off his microphone and bring down the blind so that the press couldn't see what was going on, they cut the live TV link and his comments were expunged from the final written transcript. So if you go to the website of the Special Court for Sierra Leone now, you will not see Justice Sowell's words. We were fortunate enough to have a former member of the Chamber's legal team who told us immediately what's happened. Get on the live note and seize it, because if you don't, it's going to be gone. And so we managed to seize it, and it's the only way in which a record of what he says has been preserved. Now one wonders, why is it that judges of a court would, one, seek to censure one of their brethren? Secondly, what were they afraid of? Why were they trying to ensure that this West African black man's voice would not be heard globally? Why? Because, as we've said from the outset, there was a political agenda here. And the court needed to project this image that this was a unanimous decision. And Judge Sowell's intervention upset the apple cart, and so they tried to silence him. And for me as a black man, I find that totally unacceptable. The second point I'd like to make before I shut up and give somebody else a chance is the point made about Fatou Bensouda's appointment. The parallel I draw is this. When Barack Obama was elected as the first black president of the United States, there was so much hope and expectation heaped upon his shoulders. I never believed it. I never believed the fairy tale Cinderella story. Because the fact of the matter is, even the president of the most powerful country on this planet has to work within certain limits, defined by big business, defined by the military, defined by other major interests within American society. So we shouldn't be disappointed with Obama's achievements. He has to work within those limits. The same will be true for Fatou. Fatou will work within the limits set by the Security Council. She has no choice. if she wants to preserve a career within the UN, unlike Justice Sal. She has no choice, and that's the bottom line on that.
To pick up on the question that was asked here, I think actually the Security Council referral is a very important mechanism. I have tried to outline some of the dangers in the sense that where the Security Council uses that referral power in an unprincipled manner, where it refers one situation but not another where these crimes are taking place, or where it refers a situation and then implicitly seems to withdraw its support for that referral because political calculations have changed on the part of some of those members. I think that's what subjects the ICC to being seen to be political and being seen to be politicized. But given the reality is that some states are always going to choose to hold themselves outside of the ICC system and therefore won't become states parties, I think that the Security Council referral is what gives us some chance of evening out some of these dynamics. Complicated in practice, though, complicated to get the Security Council to behave in a principled way that actually adds to the equal application of the law rather than subtracts from it. I think only want to pick up on one other question, which is about why is it okay to have an amnesty for the UK and Northern Ireland, and why not then for Sudan? Well, I think a lot of this has to do with politics as well, but to give some context to it, when the South African Truth and Reconciliation Commission came along, it was considered to be an innovation because it did have justice in the mix. The amnesty was conditional. There was still the possibility of prosecutions. And previous models in South America were just amnesties, just a complete blanket amnesty, get out of jail free card. So that was already an innovation to put justice inside that reconciliation mechanism. And time and the law keep moving on. Now a lot of those amnesties in South America, Latin America have been overturned, and we have justice processes. We have the international tribunals. And this has given rise not just to the development of law, which makes it arguably unacceptable to have amnesties for these kinds of international crimes, but also to expectations of victims. I mean, there's a good reason that you hear the refrain of sending Assad to The Hague. Increasingly, victims have an expectation, and I would say also they have the right to justice, they have the right to truth, but importantly, they also have expectations of justice. And this is the direction in which we are moving. So models that may have been considered innovations at one point, this is really my only point, models that were innovations at one point in coping with mass atrocity, time moves on, and those may no longer be the best that we have to offer.
Yes.
You just mentioned the issue again of amnesty, and it's always struck me as being very ironic that Amnesty International, of course, has actually spent the rest of its last 30 years making the case against any concept of amnesty. So I find that sort of one of the paradoxes within the human rights system.
Different kind of amnesties.
Well, perhaps amnesty. Again, we're back to defining terms, I suppose. But I'd just like to make one or two very, very quick points. What about the actual signing of the Rome Statute and those African states that actually signed it? And I use a very small insight I had. I was working within the British Parliament in the early 1980s when the British Parliament signed the Single European Act, which was the biggest single step with regards to Britain surrendering huge amounts of its sovereignty to the European Union. Now, it's a simple fact that I think I was probably one of the very, very few people within the British parliamentary system. I wasn't actually a member of Parliament, I was working for members of Parliament, who actually read the Act, or in fact actually read the bill. And a number of people, for example, Kenneth Clarke, one of England's sort of most distinguished jurists, now I think the Minister of Justice, he admits it. He never read the Single European Act. He voted for it. He went like a sheep into the actual the yes lobbies. He voted for it. He basically, along with all of his colleagues, including Mrs. Thatcher, surrendered a huge amount of their national sovereignty, the national sovereignty of this country, to the European Union without reading not just the small print, but the Act itself. I dare say much the same may have happened with regards to signing the Rome Statute. Now, one last point on the issue of why Africa signed. Why did so many African states? It wasn't just African states. I think there was a genuine belief amongst countries within the emergent world, the developing world, and also, of course, within the European Union, in some cases, that this was a genuine court that would bring to book serious international abuses of human rights. Now, again, from the very start, the second that statute was actually signed, the writing was on the wall, and for a very simple reason, which is that if you look back at the Nuremberg tribunals, and again, there are questions about those, but I think generally they did a very good job. If you go back to the Nuremberg tribunals, what was the single most important crime it addressed? Anyone here? Wars of aggression. It wasn't genocide, which of course was incredibly serious. It wasn't crimes against humanity. It was waging wars of aggression. And that should have been front and center of any Rome statute. And they deliberately avoided taking this on. They said, well, we'll actually discuss it in 7 years' time. And when they actually did a few years ago, they said, well, generally speaking, well, the UN Security Council will actually make up its own mind on exactly what constitutes a war of aggression. The biggest single failing was that, and it was right from the start. So lots of intentions, lots of good intentions, lots of aspirations and beliefs and hope destroyed by the simple fact that from the very get-go, as our friends in America would say, the Rome Statute was doomed to fail. And we were suckered in.
Can I just make one quick point? David just used the word bring to book. And it reminds me that after the UK signed up to the Rome Treaty, the then Foreign Secretary, the late Robin Cook, was asked on BBC Newsnight, so now, Foreign Minister, that the UK have signed up to this, does it mean that our Prime Minister or the President of the US might be put on trial for the illegal war in Iraq? And he turned to the questioner angrily and retorted, this is not a court set up to bring to book the likes of the Prime Minister of England or the President of the United States. He said that. So who was the court set up for? Those lesser breeds without the law.
Thank you. Firstly, we will only take questions, not comments. So those who have put their hands up to comment, forget it. Secondly, I'm going to be gender positive and optimize or maximize in favor of my gender. So there are two persons, the two ladies at that table.
No, my question just relates to, I believe, a very important point that was raised by Mr. Griffiths. I'm sorry if I can just briefly explain why I want to ask this question. Now, we understand that in order to solve any problem in the world, we need to look at the root cause. And it is with no doubt that the root cause of many problems in Africa relates to the illegal exploitation of our resources. Now, for example, if you see in the Congo, there's 48 women raped every single hour. 45,000 people die every month so that we can enjoy our cell phones, our laptops, and you name it. This is an issue that we really need to raise. It's so important. And when you think about Lubanga is not the problem of Congo. Lubanga is not the problem of Africa. The real problem are the international corporations that are illegally looting our resources. So my question then is, we're in a room with many lawyers, international lawyers. Now, what can we do to solve these issues? So how can we come together to solve it?
There's a lady, I said I was going to be... we're going to need to... Yeah, she'll be leaving. Yes, she told me.
So maybe she feels uncomfortable to leave. But you know that she needs to
Ms. Evenson has a train to catch, so she apologizes and she has to leave now. The train will not. But are we being kept to our time though? Because we're supposed to finish off at 1:45. Okay. All right. So there's a lady here, and then after that, okay, after that, then the men have a chance. All right. So then I'll call on you, and I'll call on you, and you, and you. Thank you.
Well,
and at the back there. Then I've covered everybody. But questions, please, and straight to the question, and very short on the preambles. Thank you.
My name is Nada Ali, and I'm from the University of East Anglia. I'm sorry to have to do this, but I have to relay my gratitude to Dr. Hoyle for putting the Darfur conflict in a different light. I'm completely grateful with the comparison with the Northern Ireland conflict. I did have a question for Liz, so we are gaining in time. My question is to Mr. Griffith. I do understand that the West gets up to no good sometimes, so the West does what the West has to do. But wouldn't it be easier on all of us if our leaders did not commit crimes and did not abuse human rights? And by that, they obviously would avoid being blackmailed by the West.
Thank you. Next person.
Hi, my name is Alan and I'm a student. I had a question for Mrs. Evenson, but it's unfortunate.
But yeah,
I hope
so she's not here, so...
Yeah, but maybe like the panelists will have an answer for me. So yeah, well, just about a contradiction for ICC. Well, in general, juridical system, something really dynamic. Like it's a reflection of the norms and the customs of a society that becomes like codified. I'm a bit afraid that it doesn't work for ICC because these norms are engraved forever. And well, the optimistic would say that there is the principle of complementarity, but this principle is never respected because like only a certain type of justice is recognized, which is like the retributive justice and not the restorative one. So, well, maybe there are like some international lawyers here. How would you like overcome this contradiction of international law?
It comes to this table.
Thank you very much. My name is Omar Hamid, and I am from the Embassy of Sudan in London. I have very short points. I would love to hear the panelist comments on. In fact, the ICC prosecutor or any member of his office has never visited Darfur for never one or a single time. Nevertheless, the office has, the prosecutor has, or the ICC has indicted the president and the Minister of Defense and many, 3 or 4 other Sudanese. So the question is, are we in proceeding towards what I may call distance evidence doctrine? And there is a fact that if you charge a person or a country or a suspect of genocide, there should be evidence of mass grave. No single or no any evidence like this have been found in Darfur. No mass graves. Just the prosecution relies on aerial images which taken by from air. Last point.
So what is your question? You're not making points. You're not making commentary. You're supposed to be asking questions.
I will be very specific. And the last, the question is, are we in front of distance evidence doctrine through relying on aerial images without finding mass graves. And there is a report that the Prosecutor General one time spoke in the media that he planned to divert the flight of one of the suspects. Is this going with the international law, the rule of the international law, to divert a flight or a plane or for one of the suspects? Yeah, thank you very much.
Thank you. Yes.
Thank you. My name is Charles Okwe from Think Africa Press. It seems to me that over the last few hours, the case particularly made by Courtenay Griffiths has really consigned the ICC to the scrap heap of history. It's been convicted on all counts that it's not fit for purpose. So the fundamental question for me is this, is that how can the independence of the ICC be guaranteed for the future? Because it seems that is really where the crux of the matter is. Thank you very much.
Thank you. There are more hands now. I think there was this gentleman, and then you, and then you, and then some, yes, and then you, the one with the beard. I think we're running out of time. In fact, we have run out of our allotted time already. We're supposed to finish at 2:15.
Thank you. My name is Andrew Bailey. I'm Bailey Co-International. We engage in oil and gas and other activities in Africa, as well as a lawyer. On a lighter note, I was wondering, as the emphasis is now on Africa, and that assuming that the likelihood of more arrest warrants being issued in the future, wouldn't this give rise to bounty hunters and mercenaries chasing these individuals to be brought to justice?
Bounty hunting. This gentleman, and then there's somebody who has been very patient all along. Okay.
Right.
So this one and then this one.
Okay, my name is Kwaku. I'm a lay person. I've got a couple of quick questions. First of all, I was listening online earlier on this morning. The question was asked that I don't think was addressed. Someone in the audience asked, what defines genocide? Is there a qualitative threshold? And I think it needs to be answered. My mind goes to gender, so maybe I'm a bit lazy, but I'll ask the question nevertheless. Is Israel part of the member states of the ICC? And lastly, I was intrigued by the topic, which was building restorative international justice. I've got a concept of restorative justice from a layman's point of view, trying to reconcile, maybe taking the transgressor to meet the victim. If we're talking about ICC, where we're taking Africans into The Hague or Europe, where's the opportunity to engage with the victims? My impression is that the judiciary system is about finding someone guilty or not guilty. When you found guilty, you put in a cell or some a jail. So where is that restorative justice process? I can't visualize it. And I don't know when it says international, whether that's a different concept from my understanding of plain restorative justice. So a definition might be useful for lay people like us. Thanks a lot.
Thank you. Yeah.
Two very quick questions. If Africa's on trial, for the panel to comment on, if Africa's on trial, could you please comment on who is trying Africa? In the case of Kenya, which is the one I know the most about, you have a chief prosecutor who used to be the kind of Judge Judy of Argentina. He had his own show on Argentinian TV. You have a judge who isn't qualified and has never practiced law. You have a Belgian judge who is a former folk singer-songwriter. Is this good enough for the people and the victims of the atrocities in Kenya? And second question, would it be better, given the comments that Mr. Holie made about Northern Ireland, would it be better to have an international centre for truth and reconciliation rather than a court?
Thank you. I've been informed that we need to wrap up now. So quick responses, really very quick. Bullet point responses.
Okay,
one bullet point
okay,
per panelist.
No restorative justice, that is the basic critique of the ICC, and that's the point that has to be made.
The student from the University of East Anglia asked whether, in effect, I was in favor of immunity. My critique is based on my love and respect for the law and my disgust at the way in which international criminal justice is currently being practiced. Africa has suffered enough from atrocities committed by its own leaders, from Verwoerd through Vorster, and I'm old enough to remember Emperor Bokassa, right? So yes, there is a need for an end to immunity. But to my mind, the push for such immunity has to come from African people themselves. It has to come from the bottom up. This idea of the white man coming, as in the 19th century, you know, the white man's burden, has now become bringing the benefits of international justice to black people. I reject that totally. It's for black people to do it for themselves in Africa. That's the starting point.
One or two very, very fast points. The contradictions of the ICC, absolutely, absolutely. The emperor has no clothes, and I think meetings like this, conferences like this, live and otherwise, will actually sort of more than adequately expose the nudity, the nakedness of the emperor. Having said that, it's €100 million per year industry. That office, that building there, generates €100 million. So it's not going to go lightly into the dark. It's going to actually fight its corner actually bureaucratically with sort of vigor and enthusiasm. Distance evidence, very interesting. We already had sort of more than enough material this morning on how the ICC is basically outsourcing incredibly important work to local NGOs within some of the affected countries. The simple fact is, at the end of the day, and I wanted to actually make this point with our friend from Human Rights Watch, at the end of the day, she spoke of civil society, which of course involves these NGOs. When the civil society itself is overwhelmingly funded by the European Union, and the ICC itself is a European Union project, we get blowback, which is that there is a vested interest in all these NGOs apparently actually gathering information, apparently in a very flawed way, to be put back into the process, because they are both serving ultimately the same paymaster. And on the issue of the European Union funding, in 2009, and I went through all the accounts very, very stringently, 60% of the budget of the ICC came from the European Union. 63% came from the European Union, plus those states associated with the European Union, for example, Switzerland. One last point, perhaps also, I was slightly distressed actually during Paul Moorcroft's, Stephen Sackur hard talk interview with our friend Elizabeth, when she said that, well, actually, the ICC should be getting professional judges, that the ICC should actually be, becoming more professional. It's already made, handed down verdicts with regards to serious crimes against humanity. It's already investigated and handed out indictments with regards to genocide, crimes against humanity, and war crimes. Is the reality now that those have been handed down, in effect, by incompetent pseudo-judges or judges who are appointees or judges who aren't even lawyers? Because that seemed to be the admission made, was that from now onwards, we have to get a bit more professional because we're actually dealing with important things. You've had 9 years to do this. Those are just a few points, perhaps.
So the only thing left for me is to thank you for being a very, very appreciative and very lively audience, and then also to thank my panelists for their contribution and for fielding the questions that were put to us. Unfortunately, there's not enough time because it looks like we could have gone on some more. Thank you very much.